we've talked about how some of the leading politicians and Doug Kelly haven't been responsive to interview requests. One of the things that I find angering or maddening is the unresponsiveness of virtually all of these people to answer questions in any forum. So in the U.S. Attorney's offices, for example, they've got all these public relations people who announce things, but the same thing, you try to go to a senator, the receiver, no one will talk. That's different. And people, from when I was a reporter, you could talk to all of these people, at least off the record, and people should be angry. Why aren't they responsive? Why aren't they speaking in public?
I would add quickly on the issue of political contributions. Tom Petters gave generously to Senator Coleman, Senator Klobuchar, various congressmen. But the point is, there's nothing remarkable about that. That is the way many wealthy business people operate. They give money to politicians of both parties. They pay both sides of the street. When they get in trouble, they can call their senators of either party.
There's some questions from the audience as well about Judge Montgomery in this. And I know I've got a brother who's an attorney down in Texas. I think down there they call them Lars, but I think that's just the accent. And he's always told me, Bill, a good lawyer knows the law, but a great lawyer knows the judge. Aren't judges supposed to recuse themselves or not take part in things like this if they've got these types of connections?
Problem is Minnesota, everybody's connected to everybody in the judicial system.
Let me also add that I've looked extensively at recusal law and some really appalling cases. And the problem is so much is left to the judge themselves. And the standard should be very clear. Here's what the standard is, that if there's an appearance of impropriety and even one independent person anywhere thinks there might be a problem, the judge is supposed to recuse. And the cases I've looked into, you could ask 100 people and every single one would say, yes, it's outrageous. And what I've seen, and this the Alabama Siegelman case, is the Justice Department has filed and said not one single person in the United States would find impropriety. And the judges themselves might say that. So there's no one able to enforce this.
I also noticed in the film, and I was happy to see this because when I first saw it, I burst out laughing. I've been around politics and elections a long time, so I'm kind of used to political doublespeak. But when Doug Kelly was explaining how they were being totally transparent and showing bills to the judge in secret, and then she would tell what's being paid on that, and that was transparent. We have a couple questions from the audience about ex parte meetings and in camera, and how do these things get arranged without intervention or without any amendments after the fact? I guess this is a question from a lawyer, but can anybody speak to that?
Well, once again, I'm not going to comment on the facts, this case specifically, but in camera is appropriate in some circumstances. Those circumstances in which it is not in the interest of justice for the information to be public, the information can be simply shown to the judge and it's not part of the public record. It's something we need to use very carefully because the fundamental premise of our justice system is that it's open and transparent. But there are exceptions. And in those exceptions where it truly is justified to keep something secret from the public, then we do that. Now, why the specifics of what lawyers did to earn fees off a bankruptcy state ought to be kept from the public, I'm not sure. I'm still trying to figure that out. But there are situations where something should be kept from the public. But
what
I'm
would a
not seeing
couple
it here.
examples
At
be?
least we're not seeing it here quite
Can I
yet.
ask one question?
Yeah.
Have you ever known lawyers' bills to be so important to judicial process that they're not shown to the public?
Not unless there's privileged communication to the bill. If there's privileged information, that's a communication between the lawyer and the client, then that is kept. The specific information there, but that would not be relevant in this case. So I don't get it. I'm still trying to figure out why the specifics of the bills is not disclosed to the public. Because I think it is a quite high bar that ought to be met, a stringent test to justify keeping information about anything going on in our judicial system from the public. Ex parte communication. There are situations where it is appropriate to have an ex parte communication with the judge. You need a temporary restraining order against a violent spouse. You need a temporary restraining order to get a hold of assets that are about to flee the country. There are circumstances which one party ought to be able to go in front of a judge without the other party being represented and say, I need at least temporary relief, because if I don't get it now, something drastic is going to happen. But once again, we are departing from the fundamental premise of our justice system that there ought to be all parties represented. So the ex parte communications ought to be few and far between. And there's basic principles that I would look to. As I say, I'm not going to opine on this specific case, but take it where you will.
A quick addition. Mr. Kelly said on screen there, we submit bills in secret, that is in camera, and then the judge releases them. He left out half of it. The judge is releasing redacted documents. So we don't know the entire story, correct?
Yeah, that which should be redacted is confidential lawyer-client communications. Privileged information, and that's all that should be redacted from the lawyer's bill.
Speaking of doublespeak, when I was watching this film, I didn't really realize that forfeiture really meant seizure, and I think that's the scary part of this for a lot of people. And if you've been keeping up with the news here in Minnesota, we had the situation with the Metro Gang Task Strike Force, or whatever they were called. But we also see instances where people are losing their minivans or their SUVs because they're charged with a DWI or something, and they're taking this property before there's sometimes any crime being charged or a conviction taking place. Who can speak to that?
Lawyers?
I'd say generally.
I guess it's not a good idea.
I'd say generally, I think forfeiture law is way out of control. And if we want to raise the penalty for drinking and driving, I think that's a good idea. Let's have a higher fine. Put people in jail for longer. But there shouldn't be a free-for-all for law enforcement to go and pick up an extra SUV or a Mercedes or whatever it is. Once again, forfeiture should be aimed at the assets of the criminals and those who assist the criminals, not at assets of innocent third parties, whether secured creditors, whether the victims of a crime, or anyone else. And forfeiture law, for a range of reasons, I've seen in many circumstances, I think it's out of control.
Well,